Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thank you all for joining us on this lovely Tuesday, September 5th, the day after Labor Day. And hope everyone had a great long weekend. Hopefully, able to get away and relax a little bit. I certainly know I did. I can tell you I had to kind of get away, and I was probably going to hurt somebody. Let's just put it that way. It's been a very long 6 months and even just a couple of days away. Uh, literally, I think I was so tired. I think I fell asleep about 6 p.m., woke up briefly about 8 p.m. for about an hour, and then slept the entire time. And it's probably the best night's sleep that I've had in about a year. So that was well worth it. The lovely Miss Kristen and I were able to get away there in Crime Talk 1 to a short little journey and destination. We'll talk about that more in our Patreon show. So remember, if you're not a Patreon, well, join us and I'll tell you all about my weekend getaway there. So for those who have not joined us, my name is Scott Reich. I am a practicing criminal defense attorney, 28 years doing criminal defense. So I think we have a pretty good idea of what people are thinking when it comes to prosecution and defendants in cases, and to analyze what takes place and why it's being done. So a couple things I want to talk about this evening. First, we have Lori Vallow. She filed her notice of appeal, and although they're not limited to those issues that they've outlined in the notice of appeal, it certainly goes along with what I identified as potential issues on appeal. Now, what weight will the appellate courts there in Idaho give to Lori Vallow's appeal? Well, we'll talk about it, but my guess is they're going to throw in there what they call the SOB rule, which is basically, hey, your client's a real SOB, no relief for you. But I think the bombshell news of the day that we need to talk about is Alec Murdaugh. I know, just when you thought there wasn't going to be any more Alec Murdaugh stuff, right? He's been convicted of killing his wife, Maggie, son, Paul, and gets 2 consecutive life sentences, goes off to prison, has basically lost everything, owes his attorneys a bunch of money, was filed a notice of disposition in his federal cases so that, he can basically do some time in federal prison versus there in South Carolina. And, just, get on with his life, so to speak, whatever's left. And this just shows you when you have the financial resources, you never know what you can come up with. So the attorneys for Alec Murdaugh have filed a motion for a new trial, and they have also filed a motion for a stay in the appellate courts so that they can have a hearing. They're requesting a hearing. So remember, when you file an appeal, the district court, the trial court, loses jurisdiction. The appellate court has jurisdiction at that point. They're the only court that can rule on matters. So you have to ask for a stay and basically have the case remanded back to the district court. So the district court can then have a hearing on these new allegations. And if the court rules against Alec Murdaugh, then those items in the hearing can also go up on appeal. So there is a method to the madness. And the basis for the motion for new trial is basically jury tampering. And who allegedly did the tampering? The court clerk. Allegedly, the court clerk of the Colleton County, Rebecca Hill. Apparently, she was writing a tell-all book about the murder case. And apparently, she may have been motivated, although I think it would have been a bigger story had he walked. I thought it was a little predictable. So here are the allegations of jury tampering against the juror, the county clerk, the county court clerk. And remember, the court clerk usually works directly under the chief judge. So they've got some pull and some swagger, so to speak, when it comes to telling people how things are going to be done. So let's just go through the allegations. First, apparently, the court clerk, Ms. Hill, asked jurors not to believe Murdaugh's testimony or any evidence presented by his defense. Well, I guess my question is, jurors are given certain admonitions that says if anyone attempts to talk to you about the case, you need to let the judge know. Why did these jurors wait until afterwards, until they're interviewed by the defense to do this? You would think that they would have risen up and said, hey, does that include your court clerk? Because she's telling us some weird stuff. Now, we'll have to have a factual hearing. Hopefully there'll be a factual hearing, and we can determine who do we believe, the jurors who have no dog in this fight, or Ms. Hill, who apparently is writing a tell-all book. We'll have to wait and see how that turns out. Next, it is alleged that the jurors were pressured into reaching a quick guilty verdict, telling them that their deliberations shouldn't take them too long. Once again, why would a clerk, a bailiff, or anyone be having any kind of those communications with those jurors? Now, we're going to have to wait and see if this is enough. Now, I think it certainly rises to the level of this. If you have jurors that are writing affidavits saying this is what took place, the question is did it affect them to such an extent? I mean, it's completely improper. A court clerk knows better than this. And a case that has gone on for 6 weeks, it was originally only supposed to last for 3. Why? And I've always said this. You want to cause a mistrial? Put a police officer on the stand. They always want to get that little dig in that they always say something that's completely impermissible that usually causes mistrial. And now we have clerks getting into the game, and I don't know why they are doing that at all. The next allegation is that they misrepresented information to Judge Newman in a campaign to have a juror believed to be favorable to the defense removed from the jury. Told jurors not to be misled by Murdaugh's evidence or fooled by his testimony. Once again, why is the court clerk, the bailiff, having any comments whatsoever about the evidence? If there's anyone who knows that that is completely improper, it is a court clerk. Are you kidding me? If it was determined that this is true, give Alec Murdaugh a new trial. Give him a new trial. Not that I think he's innocent, but you can't go around tampering with jurors. This woman has no right to be commenting on anything. She's not a juror. She's not in deliberations. She's not an attorney in the matter, and she's not the judge. And even the judge knows he should not comment on anything like that to the jurors outside the presence of the jury, and certainly none of these comments. So if it's true, if this is proven to be true, give him a new trial. Apparently, there were frequent conversations with the jury foreperson, including a private chat with her during the jury's field trip to Moselle, obviously, which is the scene of the crime. Why? They should have been under complete and total sequestration from everybody during that time. They shouldn't have been allowed to talk with anybody. Apparently, they asked jurors for their opinions about Murdaugh's guilt or innocence. What? Are you kidding me? Invented a story about a Facebook post on the Walterboro Word of Mouth, which is a group page, to remove a juror who might vote not guilty. We can go into a little bit of that in a minute. Prior to Murdaugh's own testimony on the stand, he instructed the jury to watch him closely, to look at his actions, and to look at his movements, which at least one juror understood to mean that Murdaugh was guilty. Once again, why is a clerk, a career personnel there at the courthouse, commenting on the case? Listen, she could be charged with a federal crime for interfering with one's civil rights. Maybe it would be good. Maybe because this woman is doing everything that Alec Murdaugh would do down there in old Carleton County and running the place like their own. But this is what happens when you have people in power for too long. They think they can get away with it. Now, we'll give her the presumption of innocence, and she should lawyer up immediately She could be facing a federal investigation for a violation of Alec Murdaugh's civil rights. Oh, the irony of it all. Apparently, Ms. Hill asked jurors for their opinions about Murdaugh's guilt or innocence. I mentioned that. Invented a story about a Facebook post on the Walterboro. I mentioned that too. Geez. Prior to Murdaugh's own, told a juror that the Murdaughs had got to her ex-husband. Denied jurors a smoke break until they reached a verdict. Told the jurors they'd be famous and handed out reporters' business cards to them after the verdict. Pressured a group of jurors to do an interview with a network news show after the verdict, but before the sentencing, and actually traveled with jurors to New York City to appear on the Today Show. Now, apparently, Ms. Hill and her co-author of her tell-all book, a guy by the name of Neil Gordon, said they'll be issuing a statement later today. I haven't seen that yet, but we'll be scouring the internet for that at any moment. The motion also indicates had interviewed several jurors and obtained affidavits in support of the motion for a new trial. And the motion also claims that Hill did these to secure for herself a book deal and media appearance that would not happen in the event of a mistrial, and that Ms. Hill betrayed her oath of office for money and fame. Geez, you ever see that done before? I don't think so. Wow. Where? Anyway, attached to the motions were affidavits, the ex-husband of a juror, copies of Facebook posts, and pages on Hill's book, Behind the Doors of Justice, The Murdaugh Murders. Once again, public employee. Why is she writing a book? Why is she writing a book? I don't get it. You should not become wealthy being a public employee. Quit your job. But man, I'm telling you, if this is true, she could have some problems. She should certainly be fired, no doubt. And if there were a new trial granted, wow. Maybe some sort of sanction imposed, costs for everybody for the new trial. That is bold stuff. But when you got jurors saying this is what happened, I don't think any judge can ignore that. Now, the attorneys, said, the clerk of the court is supposed to talk to jurors about such matters as their food, lodging, and juror pay. And in their 50 years as an attorney, he's never seen a court official discuss the matters of a case with the jury. I would agree. I've never seen anything like it. And if these allegations are true, that is bad news for the judicial system. And if you didn't just do it the first time when it came to a big case, it means you've probably been doing it for cases over the years when you've been not liking somebody in that little small town. And the attorneys also noted that if the allegations are involving a court employee, they are a state actor, and there's no choice for the state court system but to grant Murdaugh a new trial. And he added they have sworn statements from 2 jurors and no statements from others contradicting these claims, and his team is very confident the new information is accurate. And he's optimistic that they will get a new trial for Alec Murdaugh. So how did they get this information? So apparently they received some of this information. Well, I guess they're denying the information right after Murdaugh's guilty verdict that something improper had happened in one of the juror rooms. The jurors apparently had divided into 2 groups, men and women, and these allegations reportedly occurred with the women jurors. And according to the attorneys, at least 2 of the women felt very uncomfortable about Hill's communications and behavior when her book was published, decided to come forward, prompting Murdaugh's legal team to further investigate. The jurors are reportedly being represented by an attorney down there in South Carolina. And apparently looks like one of them represents Connor Cook in civil matters related to the 2019 fatal boat crash. Murdaugh's counsel said they then went door to door in rural Carleton County, attempting to interview all of the jurors on dirt roads and in places we didn't know existed in this state. Most of the jurors refused to speak with them, and they added, but for now, they've added 2 for the record. So the South Carolina Attorney General is going to have to respond to this new motion within 10 days. And if the motion is approved, like I said, an evidentiary hearing would then be scheduled to consider the matter. And Murdaugh's attorneys would have the power to subpoena witnesses, which would mean they get to have the jurors come and testify. They may be able to have all of the jurors come and testify. And yes, the court clerk herself, Miss Hill, could be forced to testify. And guess what? If that's the case, she may have to invoke her Fifth Amendment right against self-incrimination. Any attorney worth their salt is going to tell her, you take the fifth unless you get immunity. And I don't think they're going to be given immunity if that's the case that's going on, if these allegations are true. Now, sometimes, I'm not saying I've ever done it myself, but sometimes lawyers have been known to overreach and maybe exaggerate what they have. But, this isn't something they went out looking for. This came to them. And, yeah, I think the attorneys are also asking for a change of venue if a new trial would be granted. Then they'll talk about that, those issues, if those arise. But that is huge, huge news. Okay. And you would not expect it from a court clerk who's basically a lifetime court employee, been there for years. And they know better. They know better. And like I said, still haven't seen any response from her as of yet. But if it's true, now remember, this is kind of like a complaint throughout the process, whether it's civil or a criminal complaint, the allegations basically have to be taken as true, viewing all the evidence in the light most favorable to the defendant. Now, clearly, I haven't seen the particular affidavit, but if they're saying that this affected them, they felt pressured, like they had to go along, all they had to do was say, hey, when they're polling the jury, is this your verdict? Say one, say all, yes. And they go down each and every person, is this your verdict? Is this your verdict? They could have said no, but they didn't, but they felt uncomfortable. I mean, the question is, would it changed their mind, I guess, as it relates to the jury verdict? But why? Why would a clerk put herself in that position to create such a big issue and then come to figure out she's got a book deal? She should have disclosed that. And I don't know if she did. It should have been disclosed. And she should have been taken off that case in its entirety. In most places, ladies and gentlemen, we call that conflicts of interest. She's supposed to be representing the people. She's representing her own self-interest. When I mean the people, she's representing the state of South Carolina. Unbelievable. And if that's the case, let's see. Send the FBI out. We talked about in our case today, in our show today, can you trust the FBI? I don't know. It depends on who you talk to. I've had mixed results with the FBI over the years. I'm not sure I particularly, maybe it depends on the agents. It's like any organization. There's good people, there's bad people. But I wouldn't say, just because they're from the FBI, they're good. That's giving more weight and credibility to anybody than they deserve. They're not a bunch of all shucks G-men come to think that are beyond reproach. They're human. They're fallible. So let's see. Anyways, so the South Carolina FBI The Attorney General hasn't said whether he's going to ask that investigation take place, but I assure you somebody has. And like I said, this Miss Hill was a co-author of a book published on her first-hand account of the trial, a move that raised some eyebrows among some legal observers, apparently. And Mr. Murdaugh's attorney said that after Miss Hill published the book and began promoting it, they heard from jurors who felt uncomfortable about her behavior. Some passages in Miss Hill's and Mr. Gordon's book are cited in the motion filed by Murdaugh's attorneys, who argue that Miss Hill may have pushed jurors toward a conviction in order to get herself a book deal and appearance in the media. One passage from the book says that while she was chaperoning jurors on a visit to the crime scene as part of the trial, she and the jurors and law enforcement officers were present, had an epiphany, and shared our thoughts with our eyes. What? At that moment, she wrote, many of us standing there knew. I knew, and they knew, that Alex was guilty. What the fuck? Geez, are you kidding me? And then a law professor chimes in and says, that's a criminal law professor here, said he had never before heard of a clerk of court publishing a book about a trial in which she was involved. Said that the alleged actions in the Murdaugh's motions would not have been appropriate and would have probably led to a factual inquiry by a judge. So it's not just me, but this Bruce A. Green, a law professor at Fordham University, just like that, says, if it really happened, it would be really improper. Duh. Why did she not disclose this? And if this was something going on beforehand, she should fry. And maybe this is, like I said, I don't know, maybe this is what goes on there in South Carolina. When I was stationed in South Carolina, I only got to go out to the civilian courts once or twice, but maybe this is the way things are done down there. And if things are done this way and somebody didn't call this out, that everyone thought this is just business as usual, no wonder why everybody thinks that the legal system down there was so corrupt, why the Murdaughs got away with it being so corrupt for so many years. And then he got away with so much stuff that he did over so many years. Apparently everybody's doing it. All the cool kids are doing it, right? All the cool kids are doing it. Well, if Alec Murdaugh's doing it, it must be okay. You know, and if he's doing it, it's okay, then the clerks do it. I mean, it's unbelievable. I mean, I've had cases and I've had people, particularly, and it was always people that were here in Colorado, and they were like, well, you know, like, what do we have to pay to make this go away? And I'm like, well, what are you talking about? You've already paid me my fee, and I can't make any promises or guarantee. They're like, no, man, I got in trouble down in, I won't say any states, but southern states. And like, you know, you just takes a little time and takes a little money. Well, I don't know where you work, but it doesn't work that way here. Never done it. Wouldn't even know where to begin. Not going to be involved in anything like that. It'd be completely unethical, illegal. You know, you seem like a nice guy, but not nice enough to lose my law license over. But that's the way some people think, that's the way it's done. I just didn't think that anything like that ever took place. Maybe naivete on my part, I guess, but I would like to think that you would think that people in the judiciary were beyond reproach. You couldn't do anything that would even push their ethical limits. You would think that regardless of who appointed them, that they would be there just simply to follow the law, interpret the language of the law and apply the language to the facts of the case. And that's it. And not get involved for own personal vendettas or political affiliations or anything along those lines. You would think that would be the case. Like I said, that's what you think of when you go to law school. That's what you think of, that everyone is just and righteous and the police are just doing their job, you know, following the facts wherever they may lead. And that's it. And justice for all, and we'll all prevail, and things of that nature. I just don't. Maybe I'm just a little too naive these days. I'd like to think, I mean, I've never met anybody that's ever even bragged about doing anything inappropriate like that for a client or a judge, but a court clerk knows better. I mean, if you go through a long trial, those jurors, they get to know each other very well. I've seen jurors and heard of jurors that actually have like reunions because they spend so much time together. had him show up to sentencing, which is never a good fact for your client as well. When they come out of the door, they march out in order. So they all sit in the same chairs. They know where to line up after about the first day or two lining up. But the court clerk should not be doing that. Court clerk should be like, hey, juror number 3's kid got sick, and can we take a break early for lunch so they can go check on him? Things like that. That's what the court clerks do. Here's your bus pass. Here's your parking pass code so that you can get a discount at the parking garage. Not anything as it relates to commenting on the evidence, the witnesses. Totally wrong. So we'll wait and see. But if those allegations are true, if we'll give the court clerk the presumption of innocence, because frankly, she should probably get herself a lawyer. If those facts are true, she has criminal exposure. And if she asserts the 5th, then guess what? Alec Murdaugh gets a new trial. Alec Murdaugh will get a new trial. Mark my words. Now, guess who else wants a new trial? I guess that's kind of the theme of the evening. Everybody wants a new trial. Everybody wants a new trial. Oh my gosh, ladies and gentlemen, welcome to the world of criminal law. One of the things that I thought was really cool about criminal law was that it ended. Little did I know, right? You hear about civil cases. They go on forever. People that worked on literally like one case their entire career, big, antitrust case or something. That's all they do. And what was nice was, it ends from time to start. You got speedy trial. Maybe the case will be done in a year. And as you get older and you get more experienced and you get more difficult cases, then guess what you also get? You get the more difficult cases. You get the cases that, where people are going to go spend the rest of their life in prison. And what happens when you lose and you spend the rest of your life in prison? You spend that rest of your time trying to figure out ways to get out of prison. Nobody just sits there and says, oh, life without parole. I guess I'm just going to sit here and enjoy it. No, they're always looking for a way to get out. Well, the first step is what Lori Vallow is doing. And she has filed a notice of appeal, or I should say her attorneys have filed a notice of appeal. And what are the items that she thinks that were so unfair, that resulted in an unfair trial? Because remember, ladies and gentlemen, you're going to file an appeal, but it has to be an actual legal issue. If there are no legal issues and the jury just decides the facts, nobody disputes that the defendant got killed, or the victim got killed by the defendant. The prosecution alleges that it was murder. The defendant's saying it's self-defense. Not a whole lot of legal issues. You get the legal instruction. Jury comes back, and one way or the other, that's it. For the defendant's over. Prosecution loses. But if the defendant loses, they can appeal. But remember, there was no real factual issue. Maybe there was I've done trials where there's been no objections. It was such a clean trial. You had experienced attorneys, and it was just super clean. People knew how to ask questions. People knew the rules of evidence, what could and what could not come in. And so that was it, right? Boom. So when you file an appeal, you're basically saying the judge made a legal error. Sure, the jury made their decision, but they made the wrong decision because the judge made a mistake and allowed an evidence that should have not come in, and that error resulted in an unfair trial. Now remember, roughly 2% of all cases that are appealed. And also remember, you can only appeal the case under most circumstances if you go to trial and you lose. Well, think about how few cases actually go to trial in the big picture. Very small percentage. And of that small percentage, like I said, about 2% ever win their appeal where the case comes back for a new trial. Now, I've been very fortunate. I've had cases that I've lost. I know you say, Scott, my God, you lose cases. Yes, I have. But I have a string of them. I had a guy on a racketeering case got reversed. That guy was a hoot, I assure you. He claimed after we lost, he claimed I was a terrible attorney. I didn't know what I was doing. He sued me civilly, which all got dismissed. And then guess what? His case got reversed because apparently I knew what I was doing and the judge didn't. Had another one where two co-defendants go to trial. They have cases in one jurisdiction and similar case in another jurisdiction, but a key witness dies of natural causes. Well, nobody can testify as to what that person did. It's a simple Crawford v. Washington issue where the witness has to come and be subject to cross-examination. Well, this judge in that particular case let in hearsay testimony that could not be cross-examined. I mean, why this person was even a judge is beyond me. That's like first year law school stuff. And the judge allowed it in because he didn't like my clients, I guess, the two co-defendants. Gets reversed. They're like, are you an idiot, judge? This is first year stuff. But you allowed it in, case reversed, case dismissed. And they're like, oh, the case has been reversed. I'm like, yeah, I would like to set this matter for hearing so that the world can see that the court was wrong and that the defense attorneys got it right. Appeared last week in a case that got reversed 5 years ago, homicide case. We asked for a particular instruction. Judge, you need to give this instruction as it relates to non-deadly force. The judge poo-pooed it. Said, no, this is deadly force, not non-deadly force. Well, judge, we respectfully disagree. But you're the judge, and as I tell the judge all the time, Your Honor, cases come back when you don't give jury instructions that the defense requests. They do come back when you refuse those. And literally, that's the easiest way to get a case reversed is you submit an instruction that you believe is right, and it's obviously based in law and fact, and the judges refuse it. You're probably going to get a new trial. You're going to get a new trial. But these judges, they just have, it's like that guy that just always has to be right. Can never, ever admit that you're wrong. Like, I'm wrong all the time. Oh, we should do this. Oh, really? You can't do, oh, okay. I mean, you adjust and you change. Maybe that's based upon my life. You make the best decision you can based upon the information you have. If the information changes, you adjust, you make decisions. Most judges cannot, they just cannot admit they're wrong. Most judges love power. And if you're in that power, how dare you be wrong? We are all knowing. We are all powerful. If we admit we're wrong, we must be weak. We must not be the smartest person in the room. And then it comes back. You're like, okay, see you in 5 years, judge. See you in 3 to 5 years. We'll be back. Been a pleasure doing business with you. Sure enough. So we digressed there a little bit, but that's why Lori Vallow is appealing. The issues that her attorneys have presented, and all this is not all of them, nor does it necessarily include that the appellate attorneys will deem these as good issues as the trial counsel. Sometimes trial counsel fall in love with their issues, and the appellate people are like, no, you've lost sight of it. You're like, no, I really read the cases. I really think this is an issue, and then they don't do it anyway. But the first error that they are alleging is that the court erred in its order dated April 11th, wherein the court found that the defendant, after spending 10 months in a mental hospital, was competent to stand trial. So they're basically appealing the ruling for competency. The judge made a decision, had to do what he had to do, I guess. I don't know. Did the court err in its order dated November 15th, 2022, wherein the court denied the defense expert's request to send the defendant back to the mental hospital rather than to proceed to trial? Interesting issue. Was the defendant's constitutional and statutory right to a speedy trial violated by the government's repeated request for a continuance? That, I think, is the best issue for Lori Vallow, is the speedy trial. I think it's just offensive the way things took place. And the next issue, I think, is even better. Was the defendant's constitutional and statutory right to a speedy trial violated by the court's trial setting? Now, remember, in the Lori Vallow case, she was off at the state hospital being restored to competency for some 10 months. Old Chad Dave Bell, husband number 5 to Lori Vallow, his attorney, Mr. Pryor, are doing what they do, which apparently is not much because they never seem to get anything done on time. And they're asking for continuances. They don't want to go trial with Lori Vallow. They want to delay. Lori Vallow comes back from competency. The judge says, close enough for government work. We're going to trial. And then the co-defendant, Chad Daybell, files a motion saying, no, we need a little more time. We can't be prepared. And so the judge says, well, we're going to split the proverbial baby and we're going to go to trial. What was it? When did we go to trial? April, I think it was, something like that. And which was outside of Lori Vallow's speedy trial right of 6 months. And there is some case law. There's law out there that says when you have co-defendants that really the speedy trial doesn't really track with the last person in, but really who's kind of waived speedy trial in the past, and they were going to join the trials, but ultimately they severed them and they went to trial. I still think that's the best issue. I think the speedy trial right should be absolutely sacred, and but they're whittling away at it. They, being the courts and the prosecutors, are whittling away at that all the time. And don't get me wrong, most defendants will waive speedy trial, but when they don't, let's have a trial, baby. Let's do this thing in 6 months. Let's rock and roll. Let's get it done. So that's one of the issues. Did the court err in denying defense challenges for cause to trial jurors due to bias and hardship during jury selection? Yeah, I don't think that's going to be a great issue for them. Did the government commit fundamental reversible error in its opening statement to the jury? Obviously, statements that commenting on her guilt. I mean, the opening statements should be, this is the roadmap. This is the evidence that you're going to hear. Next error that they allegedly made. Did the court err and allow the government to produce evidence of other crimes or acts against the defendant under Rule 404B? Now, that is another good issue for the defense. Now, courts are finally starting to catch on to 404B evidence. And for those who aren't familiar with 404B evidence is evidence of other wrongs, crimes, misconduct that are not in the charged offense. But it has to be done for a specific purpose to show basically absence of mistake, motive, one's intent, modus operandi, for a very limited purpose that it must be shown. And as a general rule, I'm telling you, ladies and gentlemen, if the government brings in 404B evidence, that usually means their case is weak. Their case is crap, because they're coming in here trying to show you this propensity evidence, which is strictly prohibited under the law. You want an example of 404B evidence? Obviously, it was reversed on some other grounds, but the gist of it was the same. Look at Bill Cosby. They brought in all these women from 20 years. Oh, yeah, he did this to me too. One of the reasons why they threw that case out, they reversed on appeal. Obviously, there was a whole issue regarding basically the immunity that the prosecutors had promised if Mr. Cosby gave a deposition in a civil case, and then they reneged on that. But I'm telling you, a defendant has a right to be tried for the charges before them and nothing else. And there has to be very, very limited exceptions. And courts are finally starting to cut through the nonsense. There was one prosecutor, no matter what you did, she was in the DV unit. And I get it. DV is bad. Nobody should commit domestic violence against anybody. And yes, the people that usually do it are perpetual repeat offenders of domestic abuse. And so the district attorney would go and get every little municipal court case anybody ever had with a prior DV to say, look, bad person. This is propensity evidence. He is Guilty. He did it before. He'll do it again. That is what is strictly prohibited under Rule 404A and B. You can't bring it in. You can't bring in other acts. It's propensity evidence. How would you like it if somebody said, you've been accused of stealing cars in the past. Maybe you did it once. Now they're saying you're accusing you of stealing a car. You're like, but I didn't do this. I didn't steal it. Well, you did it in the past. You must be guilty. You're like the bad seed child growing up that always gets blamed for everything because, you're the one that did the one wrong thing, and it'll forever follow you the rest of your life. Every defendant has a right to be tried on these charges and these charges alone. And I think the court screwed that up. But once again, when it comes to Lori Vallow, it's going to be the SOB rule, I think. The SOB rule, I've explained it to you, is, although there was error, it was harmless because in light of the overwhelming evidence. And by the way, your client's a real SOB. Now, they don't put that in the court orders and the appellate decisions. That's what you're not going to hear. They don't teach you that in law school. They teach you that in real life. It's called the SOB rule. Let's see. Next, error. This is a huge one, I think. Did the court err in allowing the government to amend the grand jury indictment 2 years after the indictment was filed without sending the case back to the grand jury? Now, in any other world other than Idaho, no brainer. No brainer. I'm going to trial in a couple of weeks in federal court, and it's the third time they've amended it. So we have the second superseding. You have the indictment, superseding, second superseding indictment. That's how you amend grand jury charges. The prosecutor has two processes that they can take. Do we go to the grand jury for felony cases, or can they proceed by complaint and information? If you go to grand jury, you've heard the whole, you can indict a ham sandwich. The prosecutor goes in there. They go in with their detective. He tells them what they think they need to hear to fulfill the elements. The attorney running the grand jury says, here's a bill. Sign this indictment, a true bill. All you have to show is probable cause. No defense attorneys allowed. Nobody gets to cross-examine or question the evidence. That's why you can say you can indict a ham sandwich. The other route is, like I said, you got indictment or you go complaint information. The complaint information, it's filed usually in the county court. Then there is a preliminary hearing that is given as a screening device to see if there's in fact probable cause. Now, let's face it, most of the time, if you have a preliminary hearing, the judge just comes up and rubber stamps the whole PH process, and that's it. Okay, and but they can go that way. And on a complaint information, you can amend. You can file a motion to amend the charge, maybe changing the date, maybe doing whatever. But in a grand jury, you have to go back to the grand jury. They're the ones that heard probable cause. So they're the ones that have to amend it. And to amend it, the last day in trial? I mean, I told you that, and you can go back and look at the videos. We talked about this. Like, are you kidding me? That is amateur show 101. And if those same issues apply in the Chad Daybell, they should be going back to the grand jury and superseding the indictment. Now, I doubt this appeal will be done before Chad Daybell goes to a trial, but that's going to be another issue. If they're going to amend the indictment, but the prosecutor is in a tight spot, if they go and amend the indictment now, well, it looks like, that's the way you should have done it before. So I don't know. I liked Rob Wood when he came on the case. I thought he was going to be good. It seemed like no nonsense kind of guy. The other lady came in. I think she pushed the limits. I think she's too interested, and I can't remember her name. Do you remember her name, Frank? The other prosecutor. Lori Vallow case. I can see her face, black hair lady. Mm-hmm. And I think she got a little overzealous. She did these summaries, like these PowerPoint summaries, Like, what the hell was that? I mean, it was just weird. And yeah, Smith, right? Wasn't it? Frank's finding it for me because I can't remember. But I mean, but I said all along. I mean, Lindsay Blake. There it is. She was very scripted. When you watch the trial, I mean, she puts a witness up and like, we'd like to submit PowerPoint presentation number 37 into evidence. What the hell? No, unbelievable. And of course, Judge Boyce let her get away with it. But that's what happens when you get judges who are not experienced in the criminal law allowing that stuff in. It's like, what kind of, we have some sort of civil case here? I mean, what the hell? I don't get it. So we'll have to wait and see. But I think they should have sent it back to the grand jury. Any other place in the world, I've never seen it. I had one issue once, and I still think I'm right. And it was a bad homicide case with let's just say, blood everywhere, dead people, assaults of all kinds. And there's an indictment. And then they go get a supersede indictment with one count. Well, if you look at the definition of supersede, it means to replace. So I'm like, Judge, you had the indictment. They superseded the indictment, which means to replace. And therefore, those original 4 counts in that indictment are gone. We should only be proceeding on this one indictment. And I made my record every day. I preserved that issue every single day we went to court. And of course, the judge poo-pooed it. Because, my guy was accused of multiple murders and a terrible assault of the sexual nature. The SOB rule came in. And it goes up on appeal, and the appellate attorney is like, dude, this is the winner. This is a great issue. Appellate courts are like, well, come on. I mean, sure, it's not the normal practice, but Scott Reich's client's a real SOB. I mean, he did some bad things. He's been avoiding justice for the last 20 years. I mean, we can't have him go back and start all over again. I mean, he's a real SOB. Did we mention that already? Sure, it's not normal. No one's ever done it before, and we hope they never do it again. But did we mention Scott's client was a real SOB? Oh, yeah, that was it. You had to read between the lines, okay? And never did it once, never did it again. And that was the same case where we brought up all these issues about the DNA lab. It wasn't safe. It wasn't accurate. It didn't pass all their tests. And everybody looks at us like we've got a freaking third eye coming out of our forehead. Oh, you defense attorneys, you're just being silly. You're just trying to create issues where none exist. How dare you question the integrity of those scientists working over there in the lab, just doing their job, no dog in the fight. Really? Their word is questioned every day. Don't you think you get tired of your word being questioned every day? Oh, and then like 4 years later, you get the letter. Oh, by the way, there were some errors in the lab during that time with some of our quality assurances, and some of our lab numbers weren't basically right. Sorry about that. Oh, really? You mean these guys, the defense attorneys? And my defense attorney now, he's now a judge. Like, we were the biggest idiots around. How dare you question them? That's what I don't get, ladies and gentlemen. What is wrong with questioning people that say they're always right? And when they say, don't question me, that means they're hiding something. It means they don't trust it. Bring the questions on. I will answer any question you got. I got nothing to hide. But how often do people in government, maybe like I said, maybe I'm just becoming that cynical old guy. Get off my lawn, kids. The government's terrible. Oh, They can't be trusted. Well, when you start getting burned by them so many times when they're telling you you're right and you're saying, yeah, I don't think you're right on this one. And it turns out I was the one that was right. And don't get me wrong, I'm not right all the time. I am told on a repeated basis that I am not correct. But people just take this stuff as a gospel. The prosecutor said it. The prosecutor said it. It must be true. He works for the people. Well, so what? Doesn't mean he is any good. So apparently did the clerk down there in South Carolina. She worked for the people too. And she wanted to make a little money as well. Apparently she wanted to pull an Alec Murdaugh, make a little money on the side, fixing cases. Unbelievable. Next heir that Lori Vallow intends to raise on appeal. When the grand jury indictment puts the defendant on notice that she is charged with a conspiracy involving 5 or more people, excuse me, can the trial court ignore that finding and instead proceed with a standard conspiracy jury instruction? Excuse me. So, simple proposition here. The prosecution charges in their complaint an allegation that Lori Vallow conspired with 5 or more people. That is a conspiracy, an agreement between 2 or more people to commit an illegal act. And then when it comes down to it, there's no evidence presented as it relates to the 5 people that have been charged. And the judge says, oh, by God, why defense are you always raising such legal, stuff? I mean, why? The prosecution's trying their best, and here you are objecting, trying to create issues. Okay, they didn't prove what they charged, but we're going to allow them to amend that, and we're just going to go with, an agreement between 2 or more people. Chad Daybell. There it is. I don't know. When the prosecution charges it, and then they could amend it, and only the judge allows them to amend it, but then gives the I don't know. Like I said, do I think Lori Vallow is innocent? No. Let's be clear about that. Do I think Lori Vallow is innocent? No. But, ladies and gentlemen, we got to give people due process, no matter how guilty we think they are. It has been said, and I will say it again, my job as a defense attorney is to defend the despised and the damned. They're probably going down in court. They're going to go spend a ton of years in prison. And they may be guilty as sin. But ladies and gentlemen, if we, under our system of justice, allow guilty people to be railroaded, those in power will start doing it to innocent people as well, to people they don't like, maybe people that don't have the same political views, maybe people don't have the same views on anything that the person in power doesn't like. Maybe they don't like the car that they drive, the hobbies that they do, whatever. They don't like them, and they're going to say, today I pick you. Today I pick you. And your whole life is going to be completely turned upside down. And after all, I mean, we don't railroad, guilty people. I mean, they're guilty after all. And, if I'm bringing the allegations, it must be true. And sure, you're going to have to hire yourself an attorney, probably go bankrupt in the process of doing it. But don't worry about it. You're not being railroaded. The government always gets it right. They would never do that. I mean, come on, be serious. Do you actually think that would happen? Happens all the time, ladies and gentlemen. Next, alleged error in the Lori Vallow trial. Did the government commit fundamental reversible error in its closing statement to the jury? I don't know which specific question there was, but I seem to recall that there was no contemporaneous objection. And remember, if the defense doesn't object, it's not preserved for an appeal. And I don't remember him objecting in closing statement, but maybe I could be wrong. But maybe it was such plain error that he didn't have to object, and the judge should have intervened. And sua sponte, which means on his own, raised the objection and shut the prosecutor down. I don't recall that happening, but you get the gist. Okay. Should a new sentencing hearing be held due to the sentencing court not reviewing all mitigation evidence submitted by the defense? Well, this gets a little interesting here. Now, we brought you the statute there in Idaho. We've read it. We talked about it numerous times on the show. And obviously, Idaho doesn't have the not guilty by reason of insanity defense. And basically what that is it's kind of like an affirmative defense. It says, yeah, I did it, but I was nuts, crazy, wackadoo at the time, did not appreciate what was going on at the time, and therefore send me to the mental hospital for forever. Well, Idaho doesn't have that, but they have a statute that basically says if the person is in need of help, of mental health issues, that they should have a hearing as it relates to that. Now, Judge Boyce, though, said, I didn't get anything from you guys. You said you were going to have all this testimony at trial for the mitigation phase. And you guys didn't present anything at sentencing. And I was a little surprised the defense didn't present anything at sentencing. Did they think it just miraculously came in? And like, Judge, here's a report. Please consider it. I mean, you have to at least consider it. I mean, I don't know. I don't think it was some of the best lawyering ever done, but, hey, take it for what it's worth. I didn't think it was exactly the best lawyering ever on either side. Should a new sentencing hearing be, let me try that again. Should a new sentencing hearing be held due to the sentencing courts not reviewing all the mitigation evidence submitted by the defense? We just talked about that. Did the sentencing court abuse its discretion by ordering the defendant to serve 3 consecutive fixed life sentences without parole? No, I don't think so. I think that's an absolute loser. Did the sentencing court abuse its discretion when it ordered the defendant, who had been found indigent, qualified for a public defender, and had just been ordered to serve a life sentence without parole, to pay $165,018 and $18, $165,018 in fines and court costs? No, it's called restitution. Regardless of your indigency status, you have to do it. You have to pay it. So I wouldn't be too offended by that as well. It's not like she's ever going to pay it. Let's get for real. Let's get for real, ladies and gentlemen. And it says there's a portion of the record that is sealed, including all the mental health reports of the defendant and the pre-sentence report. And they say that, they want everything prepared. The hearings on the defendant's competency, the hearings to determine if the defendant should be sent back to the mental hospital. All pretrial hearings and motions, including motions to remand the case back to the grand jury, motions to determine if character evidence was appropriate, and the scope of that evidence, motions regarding the government's discovery violations, motions regarding the death penalty. All the hearing and jury trial, including voir dire, opening statements, closing statements, jury instruction conferences, return of the verdict, and all motions, objections, and any polling of the jury. So there you go. They want it all. Like all those hearings. Remember all those hearings remember they had on whether it should be sent back to the grand jury? All pretrial motions. Scope of the evidence, 404B evidence. Yeah, I don't think we got to hear that. Remember, because everything was so super secret there. Why is that not being raised? Why is it not being raised that all those pretrial motions were done and sealed outside of the presence of the court? There you go. Linda Olson lets us know Lori refused to cooperate with the mental health issues in the PSI. Yeah, but they also had other um, mental health records before. They could have called any of those doctors before that, even if she did refuse with the PSI for the mental health. So I get it. Listen, Lori Vallow's not sympathetic. I think the issues as it relates to speedy trial, that's going to be a good one. And the amendment of the indictment. Those are the two issues that have legs when it comes to Lori Vallow's case. But the others, I don't think are going to fly anywhere at all with the appellate courts. It's just not going to happen at all. So we'll just have to wait and see. And, we'll probably know how that turns out in about 3 years. You joke, you laugh. Frank laughed. Yep, 3 years. It's true. So the notice of appeal is filed. The public defender's office, the appellate public defender, is going to handle the appeal because there's not a conflict for them. So then all those transcripts have to be produced if they haven't been produced already. All the records have to be produced. Then the appellate attorneys are going to have to go through and read that. All those pretrial motions, all the motions that were filed that we didn't all get to see. And then they're going to have to make sure the record is complete. They're going to need time to review, analyze, outline, prepare, draft, revise any of their opening briefs. Okay. And if there's one thing, I've said this before, one of the 12 undeniable truths, things always take longer than you think it will. Always. And when it comes to writing a brief, a motion, particularly an appellate brief, they're brutal. Okay. Appellate attorneys need to be people that can sit in a room and focus and analyze something for a period of time. They can't be interrupted. They can't be running to court. That's why I don't do appellate work. A simple appeal, not one where you have a bunch of mental health issues, all that kind of goods. A simple appeal would probably take between 40 to 100 hours. And when I say a simple appeal, maybe a 1-week trial, maybe not a whole lot of appellate issues in it there, but we're talking 40 to 100 hours of time to review it. That's a very low estimate for something that would, 40 to 100 hours. Think about that. A week to 2 weeks, assuming you worked on nothing but that. It's like, I'm telling you, it's like writing a report. You go to college, high school, whatever. They're like, I need you to write you a 10-page paper. Oh, I'll just whip that out. But to put out real quality, it takes time. We're not talking, plugging in old chat GBT and doing that. Nope, it takes real time. So I think the theme of the evening is everybody wants a new trial. Alec Murdaugh says the court clerk was committing misconduct. Oh, man, I'm telling you, if that's true, give the man a new trial. I can tell you we had some of our best months when his trial was going on. It was great. Letitia Stout trial. It was great. We get some good numbers there. Let's watch it again. I think the world will be intrigued and they will come up with something new, different, and better, I'm sure, both prosecution and the defense. But I'm sure the prosecutors are, I was going to say a word, but let's just say they are upset beyond belief. You get a conviction on a case that took 6 weeks out of your life, cost hundreds of thousands of dollars to try the case. Everybody packed up and went down there to old Colleton County for the DAs from Columbia. And what do? The court clerk may have potentially screwed it all up. And you get to do it all over again. Oh, man. I bet that DA is livid. And they're going to go talk to the other jurors that didn't talk to the defense. And they're going to be like, I didn't see anything. She never mentioned anything inappropriate. And even if she did, I knew my job as a juror. I was going to find him guilty anyway. That's what they would say. So they're going to say it doesn't matter. Yeah, although it happened. This is, I will bet, I don't know, the biggest stake in Denver. The prosecutors will say, first, it didn't happen. But if it did, it doesn't matter. It didn't affect the outcome of the proceedings. Mark my words. That's what they always do. Just like when you file a motion to suppress. Oh, it wasn't illegal search and seizure, but even if it was reasonable, and the officers acted in good faith. You can't punish us for them relying on good faith. Come on, judge. I mean, it's only the Constitution. My God, how dare you start giving fair trials to convicted people, and next thing to guilty people. Next thing you know, innocent people will start demanding fair trials as well. Can you imagine such a concept? Oh my God. And why? Like I said, why would a court clerk who knows better? That's the part that is so offensive if it's true. We'll give her the presumption of innocence. Although, if she makes no statements and she lawyers up, well, what do we always think when somebody lawyers up? They must be guilty. Ooh, why isn't she out there if she's got nothing to hide to defend herself, right? Well, that's right, because she could potentially be under a federal investigation for violating Alec Murdaugh's civil rights. And he's got damages. He's got attorney's fees. He was convicted. How much is a man's time in the South Carolina Department of Corrections worth for every day that he was wrongfully convicted because of her malicious acts? Oh my goodness. We'll have to wait and see. All right, ladies and gentlemen, it is that time to wrap up our show. I hope you enjoyed it. We do this every Tuesday night, 6 p.m. Mountain Time. Now the conversation will continue. If you'd like to continue the conversation, we're going to take a little break. We're going to jump over, do our Patreon show. Link below is so that you can join as a Patreon member. And as a Patreon member, you get some free, cool stuff. And you also, we get the call in line and we get to talk about stuff that we don't necessarily talk about here all the time. Like I can tell you about my experience over the weekend where the lovely Miss Kristen and I jumped into Crime Talk 1 and went down and recharged the old batteries. I can tell you about that. And we talk about anything you want to, because like I said, you can call in. It's a much smaller group. And, we'll try to answer all your questions. So I want to thank everybody for watching. Thanks for joining us. We know there's lots of things you can be doing. Appreciate you being here. We'll see you next time on Crime Talk.